If you need to write a motion for court, stick around. I'm going to help you figure that out. My name is Tamara. I'm your courtroom companion. This is the channel where we talk about family court, custody, and narcissism. Hit that bell notification and that subscribe button so you'll be notified when I upload my content. As always, what I say here is just my own thoughts, feelings, and opinions around those three topics: family, court, custody, and narcissism. I am not an attorney. I'm not a therapist. So don't take any of this as professional advice. I'm just here sharing what I went through and the tips and tricks and things I learned along the way, and in my effort to help others get through the same kinds of circumstances. So in today's video, we're going to talk about how to write a motion for court. Stay tuned to the end because I'm going to share with you my experience of writing one of my first motions. I'm going to tell you a little bit about that and some things that I learned from that experience. The first step in that is to determine the need for the motion. A motion is simply asking the judge for relief in some way for your case. For example, you could ask the judge to hold the other party in contempt. That's a motion for contempt. You could also ask the judge for a motion for emergency relief. Those are just a couple of examples. Let's say, for example, the other parent is not abiding by some temporary or permanent custody order. They're not abiding by it. They have a pattern of not doing what they're supposed to be doing. They pick up the kids when they're not supposed to, or they, keep them over a holiday weekend that they weren't supposed to keep them, something like that. A person cannot continue to disobey a court order. So in that case, the need is you need to ask the judge to hold that person in contempt so they'll stop doing what they're not supposed to be doing. So that need determines that it's a motion for contempt. So once you determine need, then there are three ways that you can go about submitting or writing that motion for contempt. First, you can go to the online website for your court system or go up to the court system and get a form. So if you're doing a motion for contempt, there will be a motion for contempt form. So you can just simply fill it out, pen to paper, or fill it out online using a PDF version. So a PDF version of that form, and you can just fill it out, just type it in, and then you submit it to the court. The second way is to use a legal document writer to help you write that document. So that person is an attorney or a retired attorney or something like that, and they are offering their services to do legal document writing. The third way is to find an example out online of a motion for contempt. So go out there on the web, look for a motion for contempt, and model your motion for contempt after the one you found. Now, obviously, your circumstances will be different, but you can see the structure of it. You can see the kinds of information that they include. And let's say they include case law. So you'll want to look up that case law to see if it's appropriate for your case. Now, you might use it wrong. You might, put it in a place it's not supposed to be, or you might just misapply it in some way. And I found in my experience that that's okay. And I'll explain what I mean by that in a second. So there are pros and cons of each of these ways to write a motion. So if you use the online version or you use pen to paper version of that same form, the benefit to that is that everything that the judge needs to know is in that form. So whatever questions are in there, you need to fill them out because that's part of how the judge will be able to rule on your motion, whether to give you a hearing or just rule on it based on what you submit. So it's kind of laid out for you. There's no charge for that. So that's another benefit. But the con to that is that there's little room and little space to write. So if you have a lot of circumstances that you need to explain or something like that, it'll be harder to fit that in. But it is a version that you can use. The second way, which is to get a legal document writer, you can be confident that what they put together is pretty legally sound. Obviously, the con to using that version or doing that way is that there's a charge for that service. The third way of finding, a template online of a motion for contempt, for example, is that it's laid out for you and you can kind of model yours after it. So it's kind of simple if you do it that way. But obviously, you'll have to research and do your own case law, find case law to support what you're saying to the judge. But there's no charge for that. Right? You can do your own research and put it together. Now, I have used all three ways to write motions for court. I've used both the pen and paper version of the form as well as the online version. I've also hired a legal document writer at some point in my case. I've also found many motions out online that I have modeled my own motions after, and at some point I even used my own motions from years prior to write current motions. So I've done all three of those ways and they've all been successful. So you can choose any of those ways. You just have to look at the pros and cons and see in your case which one would be most appropriate. I can't tell you in this video exactly what to say in a motion because everybody's circumstances are different and everybody's story is different, and what you're asking the judge for is a little different. But I want to tell you about my experience when I wrote one of my first motions. Now, I did use the forms initially, both pen to paper and downloading the form and filling it out using the PDF version. When I actually sat down to do that third way of finding a motion out online and trying to model my motion after it, I want to tell you a little bit about that. So I was my ex-husband submitted a motion from his attorney. It was about a holiday. I don't even remember exactly what the issue was, but they submitted a motion. And they also, with that motion, submitted another motion to shorten the window by which I could respond. So in my court system, when you write a motion, the other side has 15 days to submit their response to that motion. And so I was responding to their motion. And I remember feeling panicked because when I got that motion in the mail, it literally said that they were asking the judge to shorten the window to 24 hours. So I literally stayed up all night. My mom and I both did. We stayed up all night long and tried to find something online to kind of model ours after. And we thought we had to submit it within 24 hours. And it was exhausting. We stayed up all night. And then I had to take off work in the morning to go submit it and file it at the courthouse, which, I didn't know that at the time. I was kind of researching and realized I have to go to the courthouse and actually file this with the court clerk. But what I realized out of that was that when somebody submits that motion, that the judge has to respond to their request to have it shorten the window to 24 hours. So I learned that, that 15-day window, that's when I learned that there was a 15-day window. I also learned that as a person who was representing myself, that I could do it. I was fearful of doing it, but we figured it out. Did I do it all right? No. Did I probably misapply law? Probably so. But what ended up happening was that the judge denied their motion. And I just took so much comfort in that because all I did when I wrote my narrative was really just tell my story. And the judge saw my version of the story. And my experience with judges in my courthouse is that there's a little bit of grace given when you represent yourself. They know that you're not an attorney. So if the formatting is wrong or you misapply law or something, that there's a little bit of grace. Not that they can go outside of the law or outside of the rules of the court, but they don't just discount your motion because you didn't write it correctly. They don't throw it in the trash, for example. They accept it. And so what I would encourage you to do is when you sit down to write your motion, just realize that you can do it. It's hard at first, but it gets easier over time. At some point, I'd written so many motions that I went back to older versions to pull templates for using them in the current circumstances. And that's another tip, is that when you write them, obviously use those templates going forward in your own case. One caveat that I want to kind of put out here was that if you're going to write a motion for emergency relief, it's called an ex parte motion. If you're going to write an ex parte motion, I would definitely encourage you to have a legal document writer prepare that for you, because the threshold that you have to meet or the standard that you have to meet for the courthouse or the judge is a lot higher, because they have to give you an emergency hearing within 48 hours. So the threshold for them to respond to that, it's a pretty high standard. Our courthouse uses the phrase, there has to be blood on the floor. And I know they don't mean that literally, but I guess it could mean literally. But let's say your children are being physically abused. They would consider that blood on the floor. If your children are in danger in some way, you have to be able to show that in your motion. And so that standard's a little bit higher. I would definitely encourage you to use a legal document writer for that. One other suggestion would be, if you're going to write a motion for modification of custody, I would have a legal document writer prepare that, because that's a pretty significant motion. You'll learn this stuff along the way if you continue to represent yourself, but definitely know that if you have to write a motion, you can do it without an attorney. Another tip is to sign your motion at the end, leave a place for a signature, and also submit it to the other party. So if your other party has an attorney, make sure that you send a copy to that other attorney, or if your other party is not represented by attorney, make sure that you send it to that other party, because when you sign, you're also signing that you're sending a copy to that other side. I hope this video was helpful to you. Please leave a comment below if you found this helpful. Also, I'm going to link in the cards above and in the description below a video I did on pro se litigant free resources. So if you're representing yourself, you're considered a pro se litigant, I put together a video on all the free resources that are available. So do check that out if you haven't already. So until next time, bye-bye.